Hello, everyone. Thank you for tuning in, and apologies for starting a little late. We had a few technical issues, but thank you for tuning in, and we'll get right to it. For those of you tuning in for the first time, my name is Uche Waneri from Premium Law Firm. I'm an immigration attorney, and today, before I start, I'm going to ask you these questions. How many of you have been or are in an abusive relationship? Okay, that's what we're going to be talking about today. The topic is Vawa, all about Vawa. And what is really Vawa? What are we talking about when we refer to Vawa? Vawa actually means Violence Against Women's Act. This is a law that was enacted in 1994 by the then Senator Joe Biden. So the purpose of this law was really to protect a lot of people who have been in relationships, especially abusive relationships, domestic violence. And Congress has recognized through this bill initiated by Senator Biden at the time to help people who are in this kind of relationships. So we're going to get into it. We'll be discussing different parts of it, and I hope you'll find this very useful. So VAWA, when we talk about VAWA, it really means it's really not a visa. It's not even its status. It's not an immigration status. It's more of a humanitarian relief. So it's an immigration relief for people who are victims of domestic violence. And like I said, it was enacted or introduced by Senator Biden, who is now our president, President Biden. And this was in 1994. So exactly, who can apply for VAWA? It's not available to everybody, but I'm going to list and discuss people who will be able to apply for VAWA. So who can apply for VAWA? VAWA are, one, you have to be a spouse, an abused spouse of a U.S. citizen or a lawful permanent resident. You have to also be a child of a U.S. citizen or lawful permanent resident. You can also be a parent of a U.S. citizen. And the good part of it is that it applies to both men and women. So now, how does one apply for VAWA? VAWA, as with all applications, is usually with the form I-360. And sometimes if you are married to a US citizen, you can do a concurrent filing with the I-360 and 4485. And then if you're a lawful permanent resident, you can also do the concurrent filing, but then you have to wait for a visa to become available in order for your 485 to be processed. There is no filing fee. That's the good part. And during the process, after submitting your application, the USCIS is going to determine all that you have submitted. They're going to do a prima facie determination. And what that means is they're going to investigate to ensure that all that you have put in support of your application is actually true. When they have decided that it's true or may be true, then they can now send you a prima facie approval letter. So once you receive that, you're entitled to apply for public benefits, public assistance, and there's a whole lot of them that you can apply for. But you have to wait till you receive that prima facie approval letter. So when you receive that, and eventually if your VAWA application is approved, that's when your I-360 will be approved. You will now know that if you didn't apply for 485, this is a time for you to apply for 485. So that's really what the process is when you need to apply. I'm going to step back now on who is eligible. So I'd mentioned that you have to be a spouse of a U.S. citizen. You also have to be a child of a U.S. citizen and a lawful permanent resident, and a parent of a U.S. citizen. So it's only the parent that has to be U.S. citizen for you to qualify. For the other two, if you're a spouse or a child, you can apply if if you're related to a U.S. citizen or a lawful permanent resident. So who is eligible? So first, you have to establish that qualifying relationship. So really, what is that qualifying relationship? It's a qualifying relationship to the abuser. And the abuser has to be a U.S. citizen or a lawful permanent resident if you are married to either one of them, either the U.S. citizen or the lawful permanent resident. You must have at one time or been married, or you may be currently married or may have been previously married to this person. So that's the qualifying relationship. And not just getting married. That marriage should have been a marriage of good faith. So it's not a marriage you would have gotten into because you intend to get an immigration benefit. No, that will not qualify, even though you have been married to that person. So you want to be careful there, that the fact that you're a spouse, if USCIS has determined previously that maybe you engaged in a fraudulent marriage, then this is not the time for you to say, oh, now I remember I was subjected to a fraudulent, to domestic abuse. So it has to be good faith marriage. There has to be a good faith marriage, and you may have been married. It's not necessary for you to still be in that marriage. I will still get into that. So at one point in time, and then if you are a child, the qualifying relationship is that the child has to be under 21 years. So child in immigration law is defined as a minor who is under 21 years. So if you're 21 and above, you're no longer a child, and that is not a qualifying relationship. Then you also, if you are a parent, you have to be a parent of a U.S. citizen. And the qualifying relationship means that a parent could be a step-parent, it could be your biological parent, and it could be an adoptive parent. So either of these will qualify as a parent, and that parent can file for VAWA. So the next eligibility, if after satisfying the qualifying relationship standard, would be that you would have resided or are currently residing at some time with the abuser. So either you are still living together, but at one point in time you should have been living together. The other eligibility requirement is having a good moral character. And when we say good moral character, what does that really mean? It means when you don't have criminal records or any serious criminal issues in your record, and you have also fulfilled your obligations, like maybe paying your taxes and just not being in trouble with the law. So those are really good moral character, and if you've been able to maintain that, you may be eligible for VAWA. The other condition, which is the most pertinent condition, is you have to establish that you've been subjected to battery or extreme cruelty. So how do you establish that? You're going to require lots of evidence. And when we say evidence, I'm not really saying, sometimes it's possible for you, because of how sensitive this issue is, sometimes victims of abuse are reluctant to call the police when those happen. And in such situations, you wonder, okay, if I don't have that proof, will I still be able to apply for VAWA? Yes, you can be able to apply, even though you don't have a police report. And how that happens is you have to be very detailed in all the circumstances of abuse. Abuse will be extreme cruelty. It could be an act, or it could be a threat of violence, which could lead to physical abuse. It could lead to mental abuse, psychological abuse. So those are things you really have to take record of. It is very, very detailed. You have to be very persuasive when you are presenting such evidence. So that's the evidence USCIS, in addition to the other qualifying, other eligibility standards that they will be looking at in order to make a prima facie determination. It's like saying that really there is something or there exists that might be, you might be eligible for VAWA. So it's very important that it's very detailed. So with or without a police report, but at least you should be able to describe all the circumstances of abuse. So now I'm going to go into who can, I'm going to go into the favorable things about VAWA. So VAWA, like I said, those who can apply are abused spouses of a U.S. citizen or a lawful permanent resident, the abused child of a U.S. citizen or a lawful permanent resident, and an abused parent of a U.S. citizen. And like I said, even though it says VAWA, violence against women, it's also, men can also apply. So now I'm going to go through a few favorable things about VAWA. So in VAWA, you really don't have to remain in that abusive relationship. So the fact that somebody has filed an immigration petition for you and has become violent or become abusive to you does not mean that you have to remain in that marriage. So that's one of the good things with it. You really don't have to continue to endure this abuse because somebody has filed an immigrant petition for you. The other point you have to know is that VAWA is a self-petition relief, meaning that you can apply without the help of your abuser or your USC spouse or your lawful permanent resident spouse. You can self-petition, meaning you can even petition without their knowledge. So that's the very essence of VAWA. You don't need their consent. They don't have to sponsor you. You can do this all by yourself. But you have to have enough facts to support your application for VAWA. So now, I mentioned before that you don't need a police report. Also, if you're U.S. citizen, if for some reason your U.S. citizen spouse, that's the abuser, or the lawful permanent resident who is your abuser and maybe your spouse, has committed an offense, which may have resulted in maybe USCIS revoking their status, that's not going to affect you, so long as you have filed your VAWA. If later his citizenship status is revoked or her citizenship status is revoked or LPR, lawful permanent resident status is revoked, that one should not affect you. And another instance is for the children, if a child is applying for VAWA, the parent of that child usually applies for the child because it's a minor and the child is under 21 years. And in so doing, that spouse or parent is able to benefit from that because you're applying on behalf of your child. So even though your child is the one who has suffered the abuse, both of you can still benefit from VAWA. That's an important point. Same thing goes for the spouse of a U.S. citizen or a lawful permanent resident. The abused spouse of a U.S. citizen or a lawful permanent resident. So in that instance, if they have a child or if the victim has a child, yes, that child can become a derivative applicant and will benefit from that application as well. You don't have to do a separate application for the child. So now, another big thing about VAWA, like I said, because of how sensitive this is, even in rape cases and all those very sensitive cases, people are not so forthcoming, coming forward. So what Congress has done was to assure people about their confidentiality of any confidential information they'll be sharing. And what we did was it had to enact, in addition to the law of the VAWA Act, it had to put in place confidentiality protections so that people are free to come up and divulge or share all this information with USCIS, helping in the determination of their VAWA applications. So what happens if you are approved? So when you are approved, you'll be placed in either in a deferred action, meaning that you will be allowed to remain in the United States and will not be put in removal proceedings. You can also, if you are approved, you'll be allowed to work. If you're approved, you will be able to adjust to permanent resident status. And in that instance, I'm going to say, if you're a spouse of a U.S. citizen, you become an immediate relative. It means you don't need to wait for a visa number. And that way, you can always apply for your green card. That's by applying with the I-360 and the 485 at the same time concurrently. But if you're a permanent resident, you have to wait till a visa number becomes available for you to get your green card. So now let's talk about marriage. So we're saying you've left one marriage, and what really is the position? Are you able to marry? Well, you can marry, but then it really depends on the time. If you have to remarry and you remarry during the application, your application may be affected, it may be revoked, or you may have negative determination. If you are getting married, if you're remarrying after the approval of your petition or application, your VAWA application, it may not really affect your VAWA application. It's not going to revoke that because it's done after the approval of your VAWA petition. But if you're doing it during your application, it may really affect it. So you want to watch out for that before you take any steps in getting into another relationship. Another interesting fact is removal proceedings. In removal proceedings, as one of your removal defenses, VAWA can be one of them. I mean, you can apply for VAWA as one of your reliefs, and in that way, you can apply for VAWA cancellation of removal. That's if you are in removal proceedings, so that's still possible. So there are different standards that apply to this, but I'll get into that some other time. So I'm now going to go into common questions that people experience with the VAWA application, so VAWA process. The first is, people have asked, what if my I-360 is denied? So if it is denied, what usually happens? It's possible, yes, it can be denied. One of two things can happen. In the letter denying it, you can either get a request for evidence where USCIS may be asking for additional evidence, or it may actually say that, there might not be any merit in what you are saying, and may have a notice of intent to deny. Whatever they decide or are leaning towards, you will know in that letter, in the body of that letter. So even if eventually it is denied, you may have an option to reapply or provide the evidence or actually appeal that decision. So in that letter, it's going to tell you the different options you have. So that's something you want to pay attention to. The next question is, do I have to remain in the marriage until my I-360 is approved? And really, the answer is no. You don't have to continue enduring or sustaining this abuse because your I-60 is still pending. It does take some time to get this approved. And if you know that, no, you can't withstand or you cannot endure the abuse anymore, you don't have to stay in there, because stepping out of the marriage does not disqualify you from benefiting from this relief. So there are certain instances, there are exceptions when you can still apply for the VAWA when you are no longer in marriage. And that I would ask you to meet with an immigration attorney to discuss those options. One of the options I would share with you is really, if you're not remaining in the marriage because of the abuse, and there is a connection between that abuse and the reason why you are not remaining in that marriage. And again, timing is an important factor where maybe before the filing, within 2 years after the filing, you have decided that you don't want to stay in the marriage. So those issues, I would say, would be better for you to discuss those options with your attorney. But no, you really do not have to remain or continue to endure this abuse because this person has filed something for you. You don't have to remain in the marriage. The next question will be can I apply for VAWA if I'm divorced? So this is also related to the previous question. So yes, you can still apply for VAWA within 2 years after your divorce, or that again, it's always good to ask an attorney so that you explore those options. So the fact that you're divorced, that's essentially what I'm saying. The fact that you're divorced does not mean you can't apply for VAWA. You still are eligible to apply for VAWA, but you have to meet those eligibility standards, which I had enumerated before, those 4 of them. Okay? And the other question is, can I remarry after filing VAWA? So can I remarry after filing VAWA? And that's really what I had told you before. If immediately after filing for your VAWA, while it's still pending, can you remarry? Really, no. Yes, you can remarry, but it's going to affect your application. But then if you're remarrying after your VAWA application has been approved, then it may not affect your application or your petition. So what if my abusive spouse or parent filed I-130 for me and it is still pending? Yeah, this may likely be the case for most people. So yes, in those circumstances, there's a technical way to merge those 2 applications, the I-130 and the I-360, but this is what you have to seek consult with an attorney. So it's still possible. If it's not been withdrawn, yes, you can still go ahead with that application. So really, that brings me to the end of everything about VAWA. So to recap, for you to be eligible for VAWA, you have to have that qualifying relationship. You have to have good moral character. You must have resided or is actually residing with your abusive spouse or person, or whether parents. And then you also have to be a victim of battery or extreme cruelty. So the standard there is extreme. So it's not just cruelty. It just has to be extreme. You have to really establish that. So it's very fact intensive, and you really have to support. You have to support your application with a lot of facts, and it has to be persuasive in order for USCIS to even consider it to be a prima facie, to either decide to be for USCIS to decide it is a prima facie determination. So you really have to support it with very convincing evidence. So that's really what I have for VAWA. And I'm going to give you a few updates on immigration that has happened in the past few weeks, I would say. The first is the affidavit of support, the Form I-864, that has been changed effective April 1st. So the amount has increased. So anybody who's going to be a sponsor should be aware of that to make sure that you reach that threshold. And as usual, if you are in the military has a lower threshold, but that amount has been increased. So you want to be aware of that. And you know the affidavit of support, you need that if you are if somebody is petitioning for you for adjustment of status or your green card. The next update is AILA on some groups have filed a lawsuit against the Biden administration. And this is really about the non-issuance of non-immigrant visas. And this has impacted some countries, especially because of the COVID. There's been travel restrictions of this country on these countries, and this has impacted people or travelers, workers coming from these countries, you're not able to obtain visas in order to enter the country. So the countries that have been impacted are Iran, China, Brazil, South Africa, Ireland, United Kingdom, and the Schengen area of Europe. So these are designated countries. And right now, these countries are really not issuing non-immigrant visas for people who belong to these countries. And that's why there's a lawsuit against the Biden administration to have them remove this ban so that people are able to come back into the country. Then the final update, which really is not an update because it's the DREAM Act and Promise Act is where are we now? Really, there's really nothing happening now. A lot of focus is on the southern border, the crisis at the southern border. So that is really that's still in the back burner for now, and nothing is being said about that. So that brings me to the end of this presentation. I hope you found it useful, and please continue to share it with others who would need this information. And if you have questions, please don't hesitate to call me. My number is 713-730-2900. Thank you for tuning in, and I hope to see you next week. Bye.